Hello, everyone. Welcome to AmeriEstate webinar. Today, terrific topic, special needs, supplemental needs. Let's sort all that out for you. We're very excited to have a special guest, Lorianne. I'll introduce her in just a minute, but I'm Rich Brown. I'm Client Services Manager at AmeriEstate Legal Plan. And today, I want to tell you a little bit about AmeriEstate. We're a legal access plan. About 9 states, but visit our website, AmeriEstate.com, give you all our information. But we help clients with estate planning, all legal services, and elder law services. And that's what we're here doing today. And today, we have a very, very special guest, Lorianne Lippy. We're very excited to have her. We're very lucky to have her. She's a consultant for AmeriEstate. Lori is our case manager for elder law services. She works with our elder law attorneys, which include special needs trusts, special irrevocable trust, incapacity planning. She assists with clients who are using public benefits. She's worked with AmeriEstate for over 17 years and served as an ombudsman in California to aid and service the clients in need of public benefits. 17 years, Lorianne. Gosh, right out of college, right?
Hardly. Getting old here. Well, thank you for having me today.
And we're here very excited to have Lorianne help us sort out a difference between special needs trusts and supplemental needs trusts. And with that, she gets this call all the time. So we thought we need to do a webinar. We need to get it out there. So Lorianne, you get this call all the time. How do you approach a response to these folks?
Well, every case is different. So we offer consultations where you can come and we'll talk about, if you're trying to qualify a loved one for Medi-Cal, or you're trying to figure out how special needs trusts work, or you're trying to get an attorney to help you create such a thing, we can help you with that. Especially if you're one of our clients, you can come to us if your membership is current and pay for a consult fee. And I will go through explaining different things to you, such as how does one qualify for public benefits, such as Medi-Cal. And I don't actually do paperwork or applications for it, but I will give you information from the legal perspective and help you with that, and also explain these various types of trust. And I also help AmeriEstate as people's families have loved ones pass away. Sometimes they will need to set up these supplemental needs trusts and these other minors trusts for their family members. And I talk to the families about that so that they understand if it's appropriate to do for loved ones or how that works. So that way they can proceed with using the proper services that their trust avails them of. So I'm going to start today, though, by talking about public benefits a little bit, because
this is where it surfaces.
Unless I actually explain to you kind of how SSI and SSDI and Medi-Cal and Medicare all work in tandem with this, it's a little bit difficult to understand why you would create such these trusts and what they're needed for. So let's just start off with talking about what SSI is and what SSDI is. Social Security Disability Insurance is what we can refer to as SSDI. SSI is Supplemental Security Income, and that comes from the state of California. All these things arise, though, from us paying into Social Security. Our federal government is the safety net that provides us through the Social Security Administration with these types of services. Even the ones that are offered at state level are fundamentally controlled in the background by the federal government. So when we pay into Social Security, we're actually paying into Social Security Disability Insurance simultaneously. If you ever notice that on your paycheck stub, you'll see that SSA, Social Security Administration, and SSDI are showing up there as paying into your paycheck. So the fund that you pay into for your Social Security is the exact same fund as your Social Security Disability Insurance. That's important to know. So if one becomes disabled after working 10 years or 40 quarters, you should always go first to the federal government and apply for your Social Security Disability Insurance. That's very important. You start with the federal government because the federal government's usually very much willing to give you disability money. It's your money. You've been paying into Social Security all these years, and now you've become disabled. So they don't put you through the rigors of what the state does. They take your doctor's information. You don't have to do special things. You just have to prove that you are disabled, and the federal government will grant you disability. And that's a very, very important thing. So sometimes because a person is young and has not earned a lot of money, that money that they basically paid in is not sufficient to give them a cost of living allowance when they do get approved for federal SSDI, Social Security Disability Insurance. So sometimes that person will then be pushed towards the state of California or a different state that they live in, in order to get the difference, to make sure that they get enough money to equal the cost of living allowance. So that's how people become what they call Medis and stuff like that. They're basically using state funds and federal funds in order to pay for their disability. And they're also getting the services of Medicare and Medi-Cal or Medicaid because their issues are so severe that they need both forms of insurance, such as people who become with end-stage renal failure or Lou Gehrig's disease. These things are approved automatically for disability. Inflammatory breast cancer, those are serious situations that you're never not granted disability for. So it's very important to understand that the federal government is the first thing you start with. I want to throw in one more thing that's kind of critical too. If we have a child that's disabled, we need to make sure that that child is registered with the federal government as disabled as soon as possible. That is critical because one thing that's lost on people is that that child is eligible for benefits through their parents paying in for Social Security, and they're also eligible to get basic care and disability monies right now, possibly. And the most important thing is that when the parents pass, that child will get their Social Security. So if you have a child who's severely disabled and is never able to work, that registering them with the federal government has been disabled is critical before the age of 18, because to do so later possibly would not allow them to register to get your benefits. So literally the federal government gives your children who are disabled your Social Security, moms, dads. There's even been times when it's been allowed for grandparents to pass these things through. So it's very important to understand that disability is basically originated at the federal level. Now you want to basically go to the state for SSI if you don't qualify. If you haven't worked 10 years or 40 quarters, then you've got to go to the state that you're living in order to ask for a supplemental security income. And that usually comes with things like food stamps, and they also put you on Medicaid or Medi-Cal, whatever it's called in their state. And that's an important thing, but you are now at the state level. The unusual part about this, though, is that the federal government in the background, even though you may be receiving a check for $1,100 or $1,200, which is called the cost of living allowance, the federal government still funds probably $800 of that. The state only pays $200 or $300. So even we get benefits at the state level, the SSI program is still actually a partnership between the federal government and the state government, and the federal government funds most of the money that you're giving for disability at state level, but they let the state control the parameters, approve who they want, and kind of control with the funds that they can match with it, such as food stamps and other things. So these are very critical to know. So I just wanted you to know that it's important to file for disability as soon as possible at federal level and find out if you qualify with 10 years and 40 quarters. And then if not, you're going towards the state in order to ask for disability. And for children, again, very important that they have done this, they're done early too. And one thing I just want to add that I run into a lot with baby boomers and other people that have had problems is that I've had many family members that tell me that they have become disabled with work and stuff like that. And then what's happened is they've had a parent who's become having Alzheimer's or other disabilities themselves, and they've stayed home and cared for their parents, and they've not filed for disability at the federal government. Well, there's an unusual rule that federal government has that if you become disabled and you don't file for 10 years and you just work with your parents or stay home with your parents and care for your parents, even though you're doing a good thing, they possibly will deny you your Social Security disability insurance and you will not get it. So it's important to file for that disability, even if you do plan to take care of family. It's important to do what you need to do to get beyond that role so you're getting your funds. And to take care of that, because to ignore it will possibly be a serious ramification to you. And one thing to know, just to finish it all off, is that once we become 65, the federal government does not consider us disabled under any circumstances. We can't set up special trust. We can't be called disabled. They just consider us old. So that's kind of a little bit of a misnomer there when they say disabled. So we're just old, apparently, to the federal government. So just kind of funny thing, but not really, right?
So that's good background and pretty complex. So I want to interject this thought very quickly that Lorianne's available for consultation as a member of AmeriEstate Legal Plan for a very nominal fee, and you'll learn a lot. I know this is a lot of information right now, and we're not applying it to your specific situation, but just know that's available, and we're going to say that again at the end. But then, so that's good background. But here come these trusts.
Okay. So this is basically, so the usage of those type of benefits is usually what causes us to have to do special needs trust and stuff. And so the first trust that we consider a true special needs trust is called a special needs trust, and S&T as it's referred to. And this is a trust that is set up under federal guidelines. It's called a D4A trust. And this type of trust basically has rules and parameters, but it's often done, someone has a serious car wreck and they're receiving a $4 million award, and they're already disabled from the car wreck. They have had other issues go on, and they've had major medical issues, and some types of things have happened, and they've been given an award. Or family members want to contribute to it, grandmothers want to contribute to it. So special needs trusts are basically established by the party, if they're capable, with an attorney. And if that's considered like a first person, they're setting it up for themselves. They cannot be the trustee or manage their
So
own
even if
trust.
they're self-established, you cannot manage your own entity.
You cannot manage your own special needs trust in any circumstance ever. They're irrevocable trusts, and they're done primarily to protect the person because they may be using SSI at this point or other benefits. And so the idea is that this will supplement their income from the perspective of providing for care for them. They may have serious disabilities where they're not able to walk and they're wheelchair bound and they need to be cared for 24 hours a day. As you can imagine, the amount of things that can happen that can lead people to be seriously disabled, can be all over the place, from car wrecks to, cancer and other severe diseases such as degenerative, Parkinson's and other things. And so and a special needs trust is basically managed by a trustee. And usually you can pick that person if you're capable. If you're not capable, though, the court will work with you. Like, let's say this came from a proceeding for a lawsuit. The court will basically insist on this usually being created. And if there's no one to do it, sometimes a professional trustee will be put in place of it. But also, too, they'll reach out to other families to manage it for the person. So a special needs trust is a very complex trust. They vary by state law.
You said that before. It really needs to be done by an attorney that is very, very knowledgeable and knows this arena very, very well.
It has to be done by an attorney. They are specialized attorneys. They know the laws, and these trusts are complex to write. So a true standalone special needs trust, or created by either the beneficiary or created by another party for them on behalf of them, is usually a very important thing. The one caveat on a special needs trust created by other parties versus a beneficiary is that it goes to court, and it must go to court because the court has to approve who's going to manage this trust, what's happening here for this individual. And at that point, the trustee actually becomes reportable to the court every year about what are these assets for the person doing,
fiduciary
how are they
responsibility.
working, right? They're basically adhering to their fiduciary responsibility to make sure that person. So again, it's a trust that's done usually for someone who's highly disabled. It's usually for other monies.
And there's very specific distribution criteria, right? Health, education, welfare. I mean, there's rules.
No, they can pretty much be distributed.
Is it?
Okay.
Yeah, okay. No restrictions. No.
There's not a lot.
Isn't there a set of restrictions to preclude them from recalculating like benefits or pulling back benefits?
Well, that's the fact that the funds are held in this trust holds them in abeyance, so they're not considered, available assets to the person, so they're not able to, take back their SSI funding or take away their Medi-Cal that they need, because they may not be eligible for Medicare yet. Because you have to wait 2 years usually once you become disabled to get Medicare. So you might be only on Medi-Cal for your medical. And yes, you might be receiving these other funds from a lawsuit, but your issues could last your whole life. And so you don't want to have your benefits taken away or your medical taken away by having, these funds. So that's why true special needs trust. The federal government a long time ago set the rules down for special needs trust and supplemental needs trust and some other trusts that are out there that are irrevocable. They're all basically set out by the federal government and defined by the IRS. So the rules that basically Social Security Administration put into place for these trusts that they worked with the federal government on, the federal government came up with those rules and the IRS wrote the rules. Those rules are in the books, and that's how these trusts exist. And when we get to this next trust, you'll see that it's even more important because this verbiage is what we use to create what we call the next type of trust. So
special needs trust. So when you become disabled, outside money coming in. That's when this trust is created. That's when this trust is operating.
It can also be your own funds funding it, such as funds from a lawsuit or funds from an accident or other funds.
Yes.
Yeah, so it can, there are other funds that can fund a standalone special needs trust. Okay, so.
So any source of money, right into the trust.
Well, that has to be agreed upon by the court. So,
I see.
So that's why. So if things are coming from outside, usually it goes to a court situation. If it's the beneficiary's own money, like a lawsuit, there's usually no court situation. The attorney is able to form it by doing the trust and stuff. And so it's not required that they go to the court usually for those.
Okay. Versus this supplemental
But
needs.
sometimes it arises in court because the court case happens and they win an award and the attorney then comes in and starts creating the trust because the court is expecting them to put something together to hold their funds. So I'll go to the next type of trust. The next type of trust is called a supplemental needs trust. This trust is embedded language that lives within our trust. And all good trust, if a trust is well structured, it will have embedded language for what we call a supplemental needs trust, and it will have embedded language for what we call a minors trust. This is a very unique trust and very, very valuable in that even grandma's trust has this language in it. So, and they can designate a beneficiary that might be necessary to create this supplemental needs trust. The beauty of this is that no one has to go to court to create this trust. An attorney creates the trust for the clients or for the beneficiary. And basically, so what would happen is, let's say your loved one, your parents have passed away and you have a sister who's disabled and she needs her funds protected because she's on SSI and she's going to lose her benefits if she doesn't have a special trust like this. Then what would happen is you would then get with our attorneys or whatever attorneys that you're working with, and you would create this supplemental needs trust. It's a little restricted in that only the beneficiaries of the trust can be party to or be a person that have a supplemental needs trust. And whatever the contingent beneficiary structure of the trust is stays all the way through, meaning that if one of the children is disabled and I'm creating a trust for my brother who's disabled, and the trust says that if he dies, his share goes to his children, then if there's anything left in this supplemental needs trust when my brother dies after he used it for his care, it will go to his children. But what if the parents wrote something that said, if all our children, basically, if one of our children dies and their share passes to the other children, then unfortunately, that brother's share would then pass to his other brothers and sisters when he passes and not to his own issue. So those are the kind of things that if
so excuse me, so the beneficiary structure that the parents set up and then the contingent beneficiary structure that the parents set up
cannot be
will
changed.
apply to this fund of holding this money in this supplemental needs trust for this particular beneficiary.
It'll apply to this new trust.
So the parents have the peace of mind that the contingency is in place and it can't be monkeyed with in the future.
Well, it also goes to show though that parents should think through this a little bit, and that because what's beautiful about this supplemental needs trust is that you do not have to know that your child is disabled. It's possible, mom and dad could be quite elderly. It doesn't have to be,
the parent doesn't have to say this is what's going to happen to this child's portion.
It's actually the trustee's discretion. So, and trustees
it can be on the fly.
Set these up for many reasons. Maybe their brother's in prison. Maybe their loved one's in jail. Something serious has happened.
You said it applies to minors too.
Yes, it applies to, but no, that's actually a minor's trust. But yes, it can be set up for a minor. But typically, it's for a beneficiary who's usually of age. So these trusts can be set up for any reason. The trustee actually has the discretion to set it up out of the clear blue if she knows that her brother's become disabled, or her love, or someone in their family's become disabled, or someone in this trust has become disabled, or they just can't manage their share. Maybe they become a drug addict. Maybe they can't be trusted that they would squander their inheritance. It doesn't mean they won't get their inheritance, but what it means is that the trustee will set up this trust, and the trustees can be usually sometimes some of the other parties in the trust. They can be some of the other beneficiaries in the trust, because not always is the trustee of the parent's trust willing to be the trustee of their brother's trust. Maybe another family member or somebody else will. So there's a little bit of latitude as who can manage this for that person. But let's say that they have become seriously involved in drugs and they can't manage their share, then these monies would be used by the trustees to help provide for their care and make sure that they have, at least medical attention and stuff like that. So, and yes, the trust can be completely defunded after a while. So true special needs trusts, the original ones they're never really funded the same way. They eventually go to contingent beneficiaries. But a supplemental needs trust can actually be defunded completely, even though it is irrevocable. It can be reversed and be revocable.
True call I got the other day. The son had died and the parents died, and the son's contingent beneficiary structure, he had 3 children. One of them was disabled, and they were panicking. What do we do with this disabled child's share? Well, we showed them these provisions in the trust and said, we could have your answer. And they set up this trust for that child. The parents never knew this was going to ever come into play. They thought their kid would get their inheritance, but it cascaded through that child.
And so it's very important to have a good quality trust that has these provisions in it. The third type of trust that's kind of embedded in this same thing, it's embedded language that comes from the IRS, is a minor's trust. Children under the age of 18 can't really inherit legally real property or other assets. And so many times these grandparents will leave, 15,000 grandchildren, be a benefit of the estate, or their mother or father may have passed and they're getting their parents' share, but they're underage. And so what happens is a minor's trust is created. And again, trustees are picked usually from the people who are available in the existing trust and the family and stuff like that to manage for this minor child. And these funds can then be given to them when they become of age. And the trustee can actually decide to give it to them earlier. Most trusts actually put the age of 25 before distributing monies to children. That's something people should think about when they're doing their trust. You can lower that to 21. You can lower it to 18. It used to be considered the age of reason. 25 is because that's when our brains are finished developing. And so that was kind of how the language became normal to say 25 in a trust. And so kind of a standard language there. But that's not always suitable. Maybe you would prefer your children receive things earlier in life. It's something to think about. But the person who's in charge of this minor's trust that they create with an attorney, our attorneys or whatever attorneys, can then decide, let's say that at 21 years old, that child is now completed college and wants to basically, start working or get married or whatever. The trustee can actually release the funds to them at that point, and the trust is gone. So a minor's trust is basically just to protect a minor from what could possibly go wrong if they inherit too much too soon. And it also gives the family and everyone the ability to try to help them, especially if they have not completed an education yet. And parents can insist in things like, my child must have completed college or be 25, and that will be adhered to. But again, the trustee does have latitude to release those rules if they think that the person is capable and is moving forward properly, and they feel they can take their
Let me give you a
funds.
scenario. So parents pass away, child's disabled, attorney says, oh, I need to set up a special needs trust for this child and deposit their share. Is that necessary?
No. And so that's the point. Thank you.
You
Rich.
said sometimes that happens.
Thank you,
And
Rich.
it's
And
not necessary.
That's a very important thing that happens a lot. When you're going to pass through your estate to your children, you do not need to go out there and set up a special needs trust, a standalone special needs trust. I find that people are baited into this a lot by attorneys. And if there's no one that's going to fund that trust, that's ridiculous, because your trust will do it. And it will occur at your passing, as long as, the trustees are kind of aware. And we normally ask these questions, even when people pass away, to the trustees. We say, are you going to need to set up any supplemental needs trust for people, or is anyone disabled in your family? We talked to them about this. We talked about how many minors are in the family. So we kind of vet for that. But you have to be careful of attorneys that are kind of preying on, I find, the disabled a lot of times, and they'll say, you need to set up a standalone special needs trust. If there's no one to fund that trust, you're going to pay $10,000 or $15,000 to create something quite complicated that you won't use, because if the only funds your child is going to receive are going to come from you, all you need to do is make sure you have a good quality trust and that your trust has these provisions built into it.
So we've created the supplemental needs trust for the child, the beneficiary's share. But then grandma says, oh, I want to gift that kid, 10 grand. Can we deposit that money into the supplemental needs trust?
No, you cannot.
Aha.
No, only the funds from the actual family's trust, or whoever created the trust that had the verbiage in it can actually fund that supplemental
So
needs.
no
trust.
outside money.
No outside money.
So
can
here
be
comes
outside.
outside money. Now we need that special needs trust.
Possibly,
Okay,
yes, that's
okay.
possibly the reason why you might need that. Now, if grandma has a good quality trust, grandma's trust should have these same provisions. So it's possible that, that could be, if the family's aware of that, when grandma passes, they could possibly, and that child's a beneficiary, they could say, well, we'd like that to be put. Now, if they're a minor, they're going to put it into a minor's trust first, usually, unless they're truly disabled, and then they're to actually probably do a supplemental needs trust.
Are they difficult to set up and administer?
Very simple, because the money basically is sitting in a trust where the trustee manages it, trying to grow the money, invested in things that are not risky. They have fiduciary liability to do a good job of this, but they're not.
I believe that account's also isolated with its own tax ID number and tax filing.
It is just like when we pass away, our trust doesn't have our social security number tied to it anymore. It has a tax ID number tied to it. So that way the IRS knows we're deceased, and that's how our beneficiaries are getting funds. When we request to do a supplemental needs trust or a minor's trust for someone, we petition the IRS, we tell them who the parent was, we give a social security number, and they give us back a tax ID number for that child's trust, and that, or that minor's trust, or that supplemental needs trust, and that becomes the tax identification number for that trust. And I could go into more detail about trust. It's not complicated. Trustees might have to report interest income that's being earned for that minor's trust or that supplemental needs trust, but that's not hard to do. And we do these things on what's called a 1041 form. And then if the person has real income, it gets added to it. So it's not really difficult to administer. You do have to be careful on a supplemental needs trust not to void or cause problems with the beneficiary, and that they don't get disqualified for their benefits, such as if they're on SSI and you go start paying their rent,
distribution guidelines.
you start paying their rent or doing something that SSI expects them to be paying, you can then disqualify them for their benefits and they can lose their SSI.
That's a great point. How does a trustee feel comfortable that they're following appropriate guidelines?
We give them the guidelines plus the Social Security, the SSI state level will give them guidelines. It's actually published guidelines about what you can and cannot do. So you can take them on a trip to Paris, but you may not be able to pay their house payment, especially if they're on like Section 8 housing. One big distinction that I just kind of forgot to mention, which is the biggest distinction of all, is that a standalone special needs trust, back to the one that's created by an attorney with the beneficiary
for outside money,
for the court, for something else, it could be the beneficiary's award for legal.
Okay.
That trust by law must repay any Medicaid or Medi-Cal benefits used by the person. So if they use $300,000 in Medi-Cal benefits at the state level, and for their SSI, disability issues, and they used it for whatever, and those benefits, those funds have to be repaid first to the state, and then the difference can then go to the beneficiaries, the contingent beneficiaries of that trust. The beauty of the supplemental needs trust that's built into grandma's trust or mom and dad's trust,
or the AmeriEstate trust, or
for that child or person who became disabled, that trust never has to repay any Medi-Cal benefits. It's completely no if they use SSI.
Huge distinction.
It's a huge distinction. So that's why it's very important that a good quality trust have the provisions built into them. And all of our trusts on every state that we do have both the provision for a supplemental needs trust and a minor's trust built into them. So it's a very, very big, important distinction. And it's the real reason why it's so valuable to be able to have the IRS and federal government allow us this ability to fund things like this, because you never know who might become disabled. You might be 80 and find out that your grandchild is, but you're too old to really account for that. But your trust will handle it if that grandchild's inheriting, or if they're going to get it through their parent who passed away before them.
Any restrictions on these two types of trusts holding real estate?
No, they can hold real property just like anything. They can hold any type of asset.
No restrictions.
No restrictions on the types of assets that are held in there. I don't know about foreign assets. Those are sometimes convoluted because people own property overseas or in a different country, but U.S. assets, yes, they can hold almost any type.
Excellent. Well, are you?
They may not, things like 401ks, life insurance, IRAs, and annuities. Sometimes life insurance can be put into it, or insurance that's going into it. 401ks and IRAs typically cannot be held in a trust that's irrevocable unless tax is paid on them first. So you can't hold an asset that is still taxable, where you haven't taken the distributions or you're inheriting your mom and dad's IRA. You can't push that into the supplemental needs trust. And that, now you can make that IRA payable to the trust. And so in that way, sometimes it does allow it, but usually the funds will have to be paid tax on for it to be able to be ported into the supplemental needs trust.
Very important the trustee. It's been described to me that, the trustee has to distribute appropriately. If the child says, you will buy me that $10,000 big screen TV I always wanted and take it out of my trust funds, that's starting to get dicey, right? Because then you got you can't have a trustee that's subordinate to the ultimate beneficiary.
You don't, but you try to help as much as you can. When a person's disabled, sometimes their needs are just unusual, and that they just want that TV because they're handicapped and they want to be able to have that good TV.
But if that's not in the distribution guidlines, that could be impacting state benefits they might be receiving.
Things like televisions and gifts like that, computers and stuff are fully allowed. It's usually subsidizing rent if they're on Section 8 housing that causes you a problem, or to subsidize their housing if they're being given a housing allowance. And
are they allowed elements of cash distribution for sundries?
You can, but normally you have to buy the things for them. It's very difficult if you give them cash and you cause them to be over a certain amount in monies at the end of the month, and you can cause them to lose their benefits.
But mostly it's a matter of, hey, trustee, please take an element of my share and pay my medical bill. Take an element of my share, pay my rent. Take an element of my share and pay my University of Nebraska tuition.
Usually things like that. And so, but medical bills normally are being paid by their health insurance, like on SSI or something like that, and Medi-Cal or Medicaid. So usually you're not involved in paying those things, but you may have co-pays you have to pay.
I want to interject. Folks, submit your questions. We're not going to do a question and answer today, but we will trail in with answers to all those questions with the trailing email offering the replay to this webinar. So make sure you give us your questions and
I'd like to, let me see for a second here.
I wanted to say again, Lorianne is available for consultations as a member of the AmeriEstate Legal Plan and for a very nominal fee. And I've never heard anybody come out of one of these consultations saying that it wasn't the most informative visit they've ever had. And what makes their head spin going in, coming out of the conversation, they have direction, they know what to do, they know how to proceed, and we're here to assist.
I will help people talk about what benefits are available to them under Medi-Cal, Medicaid programs in various states, and also things like veterans benefits and stuff. So I'll explain those programs to you. I don't actually help people apply for things like this, but I will tell you what goes on in qualifying and try to help you with those type of things in different states.
Lorianne, can AmeriEstate write you a special needs trust?
We don't do standalone special needs trusts. We can refer you to an attorney who will do them, because again, there's specialized attorneys that deal with the laws in their states. And so those trusts have to be written by those attorneys. And sometimes, again, if it's not actually someone who's the beneficiary themselves establishing it, there's probably going to be a court proceeding in order to put that trust into place.
So AmeriEstate can get you that appropriate resource to write that trust.
With our legal plan, we can ask basically our legal plan attorneys across the country what we're looking for, what you're looking for. We can position it to them. We will get back a couple of usually many replies. We allow people to speak to 2 or 3 different attorneys to see what they think of it. They offer discounts to you if they're coming through the legal plan. And that's a pretty important thing in this type of case, because you've got a situation where you've got a very expensive trust normally. So if you can get a little bit of a break on it, it's a wonderful thing. And these supplemental needs trusts that we do, we don't charge, $5,000 for these things. Normally run minors trust and supplemental needs trusts normally run a couple thousand, because they are a little more complicated to set up and a little more parts and pieces to them. But they are not $15,000. Many attorneys charge enormous amounts of money to do these supplemental needs trusts. Again, we at AmeriEstate exist for you. We're here to help you with your loved ones, your family, your needs. We are not here to make a lot of money for attorneys. And so that's the goal. We pay the attorneys a fair fee for these things. And then we're the scriveners that type everything up. And we also stay here and help you do deceased estate administration. And then when we do deceased estate administration, when your loved ones pass and you're coming to us to take over as trustee, we talk to you about these things. Do you have disabled people in your family? Do you have minors? that are going to be inheriting. So we ferret all that out for you so that you have somebody to guide you through this. You don't have to try to guess at all this. That's why we believe in cradle to grave service here a little bit to help you with these situations, because all of us in life need this type of help sometimes.
Again, lots of information. Like to have you schedule the consult with Lori to apply it to your specific situation. And because this is a very high level. And Lori, anything else?
I think that does it.
Well, thank you very much. We really appreciate your time sorting this out. Thank you, everybody, for attending very much. We look forward to seeing you on AmeriEstate.com website. Lots of information there. And for all your estate planning needs, come see us. Thank you very much.
Take care of yourselves. Good day.
Thank you, Lori. Bye now.